125(1), the judiciary is the organ of state vested with the power to administer justice. And if the honorable nominee who asked the question, the honorable member, right, in that context, in the peculiar context of Article 142, the judiciary is defined to include the regional tribunals. What he left out is Article 142, I think, clause 3, who says, and such other courts and tribunals as Parliament may by law, tribunals, and 2, who was, mandatorily required to be a lawyer, and 2, other persons who were non-lawyers, selected from the community. Space in the administration of justice in a limited fashion. The PNDC, in its wisdom, broadened public participation in the administration of justice through the tribunal system. Now, you reference a report by Africa Watch, of course, of the Center for Public Interest Law, a human rights organization that I founded and ran for 10 good years, that conducted public interest litigation and represented persons whose human rights were being violated. So if you remember the famous case of Sodom and Gomorrah, I was a lawyer for the thousands of displaced persons in Sodom and Gomorrah using the Center for Public Interest Law. And so I'm very much aware of what Africa Watch stands for, right? But look carefully at the report, the date of the report, of the coming into.
This is not Africa Watch. And he's aware.
Wait. The document is it an organization's report, or you are quoting from a publication?
It's an organization's report.
And what is the name of the organization?
The organization is Africa Watch, Human Rights Watch Group.
Okay, Leonard, then in reference to that, please quote it well. Respect.
Yeah, thank you, Mr. Chairman. I was very much aware of the fact that it's the human rights wing of the Africa Watch, but I was just referring to it in the manner that the honorable member stated. So if you look at the date, okay, my hunch is that the empirical evidence for a report dated very close to the first quarter of the public tribunals were administering revolutionary justice in the context of PNDC Law 1. Now, if you look at the land at the time, there was no human rights chapter. In resetting Ghana, we will reset it in accordance with the 1992 Constitution. And the 1992 Constitution is very clear, that the sovereign power of Ghana rests in the people of Ghana, in whose name and for whose welfare the powers of government should be exercised per land. That includes the public tribunals. I believe that it is not your view, honorable member, that the public, by Chapter 5, the human rights provisions and the entire Constitution, guided by the directive principles of state policy in Chapter 6. And so the proposal in our manifesto is to re-establish the regional tribunals with criminal jurisdiction that is, coordinate jurisdiction with the High Court. And then we will have the circuit tribunals in all the districts, in all the, the regions, and then also the district tribunals that will also dispense justice. Thinking, going into this office, is that we will enact a Public Tribunals Act. That will be comprehensive and that will, contain restrictions in terms of the conduct, of the affairs of the tribunals and the human rights violations that are, referenced in the Africa Watch Human Rights report will hopefully not occur. Not under my watch as the Attorney General of this Republic.
Thank you very much, Honorable Bafo. Before you proceed with your second question, Honorable Mahama Yariga has a follow-up.
Good. Honorable Attorney General nominee, do you intend to establish tribunals that will use caning and lashing of people?
Mr. Chairman, I do not, and that will not be permitted by the Constitution of the Republic. In fact, that will be inhuman and degrading treatment of our citizens.
Minority Leader also has a follow-up, so you may wait for your second question.
Honorable nominee, have you become aware of the establishment of the ORA?
Honorable Minority Leader, a follow-up question must relate to the preliminary questions or the substantive question asked. But this is completely unrelated to the substantive question asked. So hold it. When it comes to your turn, you can pose these questions. Honorable
Chairman, with respect, please hold your horses. Let me make a point. We are dealing with matters of public tribunal. We are talking about issues that go complementary, okay? As far as possible from all that you've said. I am trying to appreciate the point you made in to be, chasing people here and there. You responded that no, because it will not be in accordance with law. Correct? In the same spirit, I am asking you that the ORA, that committee, which we've been told is to receive information from the public regarding supposed looting and all that. If you become aware of it, do you think that its establishment is in accordance with the Constitution?
Honorable Minority Leader, I believe the question asked relates substantially to Article 1261B. This oral that we are bringing in is not related to the establishment of the tribunal as stated in the NDC manifesto. So I reiterate the point that you can hold it when it gets to your turn. You ask a substantive question, but this cannot be accepted as a follow-up question. Thank you very much, Honorable Leader. Honorable Bafo, proceed with your second question. Leader, I cannot ask a member to proceed with a question, and then you ask that he should hold on. This is unacceptable. It's completely unacceptable. So, Honorable Bafo, proceed to ask your second question.
Chairman, take it easy. 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 The nominee in a tribunal which will carry canes to lash people responded that that would be unconstitutional. They disagree with me. Chairman, we are being cooperative, but please, he has raised a constitutional matter that if he establishes a tribunal with canes lashing people for the purpose of ensuring justice, it will be unconstitutional. Now, it is in that spirit that I am asking him, because he has raised a constitutional matter, that there are things that if you do, it will be outside of the constitution, and he as AG won't do it. So I am asking whether or not he's become aware of the aura, and if he has become aware of the aura, its mandate is within the ambit of the constitution because he has raised it. So it is flowing from the very answer he gave on the constitutionality of the functions of a publicly established body, such as a tribunal. So, Chairman, I do not see why we should be locking horns on this matter. But however, if you insist, I will...
Yes, I insist that the question is unrelated to the question posed to the nominee relating to the establishment of the tribunal as contained in the manifesto of the National Democratic Congress. Honorable Bafo, may you proceed to ask your second question.
Honorable nominee. The question was, what is it that the high courts, regular high courts, are not doing that you need the tribunals to cure? On the question of the promise that you are not going to set up a tribunal that will cane people, Honorable nominee, are you aware that there is that regulated by statute, and that statute does not include private citizens called ORA, something like that in the criminal, in the statutes of this country? Are you aware? Yes or no?
Honorable members, I know the nominee is capable of answering the question, but in our Criminal and Other Offences Act, as well as the procedure.
Well, I'm sure the honorable member himself well knows that Act 30, the Criminal and Other Offences Procedure Act, does not create bodies, organizations, agencies, or entities that are mandated to operationalize criminal procedure. It merely lays out the procedure relating to criminal trials, whether summary trials, trial on indictment, and so on and so forth, and then relating to how you treat evidence in criminal matters. So it does not create bodies. So I would not, to your answer, now the question whether oral is legal has been raised, by various people within the media, right? Oral is the operation recover or loot. If you look at the preamble to the Constitution, it is very, very clear about what are the fundamental values underpinning the Constitution. Oral is supposed to exact accountability from persons either politically exposed sources by way of property, money, and other intangible resources. So oral is constitutional. Oral is legal. In fact, the fact that it is a non-legal body doesn't mean that it is illegal. There's a distinction between non-legality and illegality.
Mr. Chair, please, if I may be allowed a follow-up.
Yes, you have my discretion. Before then,